Hello, good morning. I'm Kalpana Bharti, Assistant Professor, IIMT College of Law, and today I will discuss a very important topic of our criminal laws, that is criminal justice administration. I will give you a broad overview of this topic. So, first of all, we have to understand what is crime. So, crime is an unlawful act that is forbidden and punished by the state or the law. The expression crime has not been defined in Penal Code 1960, but there are some important characteristics of crime. Jerome Hall's extensive analysis has resulted description of seven interrelated and overlapping characteristics of crime. First characteristic is harm. There must be some injury by a person to another person to form a crime. The other characteristic include the outlawed or breach of law. Without any breach of law, there cannot be any crime or offense. The third characteristic is conduct, that is act of a person, and we also called as actus rea. So, act of the person must be some violative to any a law or in India or any other law. So, other characteristic includes the mens rea, that is guilty mind or intention of a person behind that act of crime. So there must be some fusion between mens rea and the conduct. Without any fusion or any casual relation between mens rea and conduct, there cannot be any form of crime. The other last and important characteristic of a crime, there must be some punishment for that breach of law. So now, conceptualizing the criminal administrations. The aim of administration of criminal justice is that the guilty should be detected, convicted, and duly sentenced. Criminal justice administration concern the procedure by which substantive criminal laws are actually implemented. Criminal justice system is in India is composed of three main components: the police, the judiciary, and correctional system. Type of criminal justice system. So there are two important criminal justice system. First is inquisitorial system. In inquisitorial system, an extensive investigation and interrogation carried out under the control and supervision of court to ensure that innocent person is not subjected to trial. The defendant has the burden of proving the innocence. So in this system, court took a important part in investigation and other supervisory function of the court. So other system is adversarial system. Under adversarial system, an accused is presumed not guilty, and the prosecution is to prove beyond all reasonable doubt the guilt of the accused. This system presumes that the best way to get the truth is to have a contest between the prosecution and the defense. So, in adversarial system, a court does not have that active participation in finding out the truth, but prosecution and defense has to contest between by producing their evidences so that court can come to judgment. So there are models of criminal justice process. Herbert L. Packer gave two model of criminal justice process. First is crime control model. The criminal conduct must be kept under the tight control in order to preserve public order. Other model is due process model. It protects an accused from coercive, easily abused power of the state. So, John Griffith gave another important model of criminal justice process, that is family model. An offender would be treated as a person with respect, and the role of the society is to perceive an crime occurrence as criminal deviance and reacting to it accordingly. So, in criminal justice system, there are important roles which has to be played by prosecution, defense, and our judges. So now come to the role of prosecution. The prosecution is responsible for presenting the case against the accused and ensuring that the justice is served. The prosecution is responsible for collecting evidence, interviewing witnesses, and preparing the case for trial. The prosecution also has the important responsibility of ensuring that accused is treated fairly and their rights are protected. The prosecution plays an important role in the criminal justice system as they are tasked with the responsibility of obtaining a conviction. They must present a strong case against the accused and prove that they are guilty beyond reasonable doubt. The prosecution has the responsibility of ensuring that victims of the crime are provided with justice. So now, role of the defense. The defense is another important part of criminal justice system in India. The defense is responsible for representing the accused in court and ensuring that their rights are protected. The defense is responsible for ensuring that the accused is treated fairly and that interests are safeguarded. The defense is also responsible for presenting evidence in the defense of the accused and for arguing for a lesser sentence. So, defense plays an important role in criminal justice system as they are tasked with the responsibility of ensuring that accused is treated fairly and that their rights are protected. The defense must also has also present a strong defense in order to protect the rights of the accused and ensure that justice is served. So this is the role of defense. Just the main role of defense is just to protect the right of accused, so that because we believe in innocence of a person until he is proven guilty. So his right must be protected by the law of the land. So now come to the role of judges, which is very important. There are two important role in criminal justice system of the judges. First is pre-trial judicial role, and other is judicial role at trial stage. So pre-trial judicial role include the granting of bails and sending accused in police or judicial remand, taking preventive measures such as to order the arrest of person and allowing a preventive detention, etc. The judicial role start at the trial stage. So this role uh, include adjudication of the matter, sentencing, and deciding some few important questions. Those important questions are why to punish and how to punish. So now come to the punishment part of the criminal justice system. In Indian Penal Code, section 53, there are five kinds of punishments. First is death sentence. Second, imprisonment for life. Third, imprisonment with the sentence, which can be simple or rigorous. And other is fine and forfeiture of property. So now come to death sentence. Death sentence, which also called as capital punishment. In some of the cases, Supreme Court has held that capital punishment or death sentence can only be given in rarest of rare case. So it is not a normal rule to give a person or accused a capital punishment. So this is the important thing about these punishments in our Indian Penal Code. Now, now come to after punishment, there are some hearings, some important hearings before giving punishment to a person, and these include the pre-sentence hearing under Section 235 CRPC. This procedure of pre-sentence hearing is given. So, after hearing argument and point of law, the judges shall give a judgment in the case. If the accused is convicted, the judge shall, unless he proceed in accordance with the provision of Section 360 CRPC, hear the accused on the question of sentence and then pass sentence on him according to law. In important case of Santa Singh versus State of Punjab, Supreme Court has held that provision of pre-sentence hearing is oriented toward a socio-economic purpose and toward the goal of attaining a ideal balancing in sentencing process. The law seems to urge the court to not simply look at the crime but also the criminal before deciding upon the sentence. It seeks to trigger a legal adaptation of the modern understanding of the criminal as not a menace which needs to be eliminated, but as a diseased mind which must be cured and rehabilitated. In this context, the court must take into consideration fact which otherwise may not be relevant in a criminal trial. So, This approach is evidenced by the aim and object of the CRPC 1973 itself, which mention about due consideration being given when the person to be punished is the sole breadwinner of the family. So these are the important consideration in this case by the Supreme Court about the pre-sentence hearing. Now, in punishment, uh, some of the provisions are very important, which a court took into consideration. And one of the important development in deciding a case and giving punishment is the process of plea bargaining. The plea bargaining in law is the practice of negotiating an agreement between the prosecution and defense where the defendant plead guilty to a lesser sentence, or in the case of multiple offense, to one or more of the offense charged, in exchange for more lenient sentencing recommendation, a specific sentence, or a dismissal of other charges. So, under section 265A to 265L of CRPC, this process of plea bargaining is given. And it is applicable when police report is forwarded under section 173 CRPC and where the offense is not punishable with death penalty or imprisonment for life or any imprisonment exceeding 7 years. So it also not applicable where offense affects the socio-economic condition of the country or committed against a woman or a child below 14 years. So guidelines about this process of plea bargaining is given under section 265C to 265L. Now there are some correctional measures the court adopt in criminal justice administration also. Some correctional measures include the admonition and probation. Admonition means the releasing a person by the court after a reprimand. So, and probation includes the provision related to probation we get under Section 360 CRPC and Section 4 of the Probation of Offender Act. The probation means releasing a convicted person on probation of good conduct under the supervision of probation officer for maximum 3 years upon entering into bond with or without surety to receive sentence when called upon and till that time to maintain a peace and good behavior. So in admonition, a person is released by court or after reprimand, and probation, a person is released on some conditions uh, to uh, to come back and for complete his sentence for minimum or maximum about 3 years. So, according to section 360 of CRPC, person may be released at the discretion of the court if the accused is beyond 21 years of old and he is convicted only for fine or for the imprisonment 7 years or less than 7 years, or accused it below 21 year of age, or is a woman and he is convicted for offense punishable with the death or imprisonment. And in either case, previous conviction is not proof, then person can be released on probation by court for maximum period of 3 years by the trial. Court may decide to release an accused on probation by looking into past antecedents, age, character, and the circumstances in which the offense was committed. So, such power may be exercised by the appellant or revisional court. So, this is all about probation and admonition of um including the other correctional measures by the court. So now come to the rights of defendant in criminal justice system. So this all about after discussing this entire process, we have to understand what are the rights of defendant or victims, in which are two main parties of a criminal justice system. So first of all, constitutional right of defendant include under the Constitution of India, which is provided under Article 21, 20, 21, and 22. So, under Article 20, the protection in respect of conviction and punishment under an ex post facto law, safeguard and by safeguard against double jeopardy and against incrimination is given in this article of 20 of Constitution of India. So again, we have to come the important life and personal liberty of defendant, which is given under Article 21. So as per this article, no person shall be deprived of his life and personal liberty except according to procedure established by law. But in important case of Menka Gandhi case, it was held that the mere prescription of some kind of procedure cannot be even meet the mandate of Article 21. The procedure prescribed by law has to be fair, just and reasonable, not fanciful and oppressive or arbitrary. So this is one of the important right of defendant in criminal justice system. Other right include under Article 22, that is protection against arrest and detention. The procedural safeguard against arbitrary arrest and detention provided in clause 1 and 2 of Article 21 are that no person who is arrested shall be detained in custody without being informed as soon as may be of the ground of such arrest. So before arresting any person, he should be informed about the grounds of his arrest. Now come to the victim justice. After knowing the rights of defendant, we have to understand what are the rights of victim. So the word victim defined in CRPC section 2 WA. Victim means a person who has suffered any loss or injury caused by any reason of the act or omission for which accused has been charged. And expression victim include his or her guardian or legal heirs. So victim can be any person who has suffered any loss or injury, and it include his guardian or legal heirs both. So victim's right to some of the right important right is that victim has a right to participate in the process of criminal justice administration. So a victim within the meaning of CRPC has a right to be heard at every step post occurrence of offense, including the stage of adjudication of bail, application of the accused. He or she cannot be asked to wait for the commencement of the trial for asserting his right to participate in the proceedings. So, victims' rights. The two significant remedy of criminal justice system are compensation and restitution. The other right include the right to appeal if victim is not satisfied with the judgment of the court. So there are two types of right to appeal given to the victims. First, section under section 372 allows the victim to appeal against the acquittal order, a conviction for a lesser sent offense, or inadequate compensation given by the court. The other right is given under 439, section 439, clause 2. So, by virtue of this section, the victim can appeal against the bail granted to the accused. Some special protection are also given to rape victim. So victim's right, first is victim right to compensation is also available to rape victim. Was a new provision which has been introduced as section 357A of CRPC, which state that victim compensation scheme. The Supreme Court has laid this provision down before framing a scheme for compensation with Nippon Saxena versus Union of India. Keeping this in mind, National Legal Service Authority made a rule for compensation scheme for women victim. Other right of rape victim include the free medical treatment in any private hospital. So according to section 357 of CRPC, no private or government hospital can charge fees for the treatment of rape victim. So this is all about our criminal justice administration, and by all giving the rights to the accused and the victims, our court try to balance between both giving justice to the victims and also protecting the rights of the accused. So this all about our the criminal justice system of India and the some main features of criminal justice administrations. Thank you.